This is me and our firm. We specialize here in only a couple of things: estate planning, so it's drafting of documents, the administration side, probate administration, trust administration. We do guardianships and prenups. So part of our estate planning side is tax related, and we help clients reduce their estates so that they don't pay estate tax, hopefully. All right. So we're going to start with some basic overview, the 2025 exemption and the 26 exemption. Some of you might have heard in the news, the exemption is now permanent. It's permanent until it's not permanent. It is not scheduled to sunset like it was previously scheduled. At the end of 25, it was going to revert back to some older numbers that were going to be probably about 6 or 7 million. But now they did make the law permanent. So in 26, the exemption is going to be $15 million per person. So an individual won't pay estate tax unless their estate exceeds $15 million. A married couple can shelter $30 million for the most part. So most estates are not going to pay estate tax, at least at the federal level, unless you're over this. Some states also impose a state level estate tax, and a few states have an inheritance tax. Florida does not impose an estate tax or an inheritance tax. So here, if you live here, you're just looking at the federal exemption, unless you own property. So if you own real property or assets in other states, then you will also be potentially subject to the estate tax in those states. Some of them are very unforgiving, so it's very important that you look at that and plan for that. If you are a non-U.S. person, and this is based upon domicile, not residence, the landscape looks very different. They only get a $60,000 exemption, hugely different from a U.S. person. Domicile is a tricky little thing because it's a subjective decision. It's a subjective analysis. If you have a green card, you're not necessarily domiciled here. If you have a visa, you're not necessarily domiciled here. Domiciled is based upon a lot of factors. Having a green card is certainly a great place to start. If you're a citizen, you're a citizen. That's it. You're a U.S. person. But if you're not a citizen, then we have to look at all these different factors to determine whether or not you might be domiciled here. And domicile is really, do you have an intent to remain in the United States permanently? Is this where you plan on staying? You could work in the United States for 30 years and always intend to go back to your home country, in which case you are not domiciled here and you only get a $60,000 exemption. You could own a $100,000 condo and you're going to pay estate tax. The only country that has a very impressive exemption would be Canada. So citizens or residents of Canada who own property in the United States have a very nice treaty that they can avail themselves of, but you have to file, or your estate has to file, a 706, which is an estate tax return for a non-resident, in order to avail yourself of those treaty benefits. And you get a percentage of our exemption, which is currently almost $14 million or $15 million next year. So Canadians usually make out okay, but most other people do not, and they're usually caught off guard with that. So there are strategies that you can do to try to avoid the estate tax if you are not domiciled here. Annual exclusion gifts. Okay, so this is one of our first strategies. This is a no-brainer. If you have a taxable estate, making annual exclusion gifts is a no-brainer. You got to do this. You can give away $19,000 per person every single year. If you're a married couple, you can give away $38,000 per recipient. So fun fact down below on the slide, if you have, what do we write? 4 children and 8 grandchildren, you can give away $456,000 annually. Obviously that seems like a lot, but $19,000 might not seem like a lot. But if you're doing this consistently and really giving it to everyone, kids, grandkids, Doesn't even have to be anybody that's related to you. It can be, stepkids. It could be friends if you really want to be generous. This can really add up over time. And this is a complete freebie. So this does not use up any of your $15 million exemption. This is just a complete freebie. You can make these gifts outright to someone, or you can make them into some sort of trust structure so that they can't use the money right away. Very beneficial. Unlimited medical and education payments. These are another freebies. I think a lot of these get overlooked by people, but you can pay medical and education expenses of an unlimited amount for anyone. You have to pay the expenses directly. You can't reimburse the recipient. But so this could be for, your kids, your grandkids. It also includes the medical insurance premiums. So this could also be very powerful. It does not use your exemption at all either. So this is a strategy that should be looked at to reduce your estate. Now, maybe some of your kids have children and some don't, and you want to even everybody out. You can do that in your estate planning documents, but don't miss this opportunity where you can give away money tax-free, because it all adds up over time. ILITs, these are irrevocable life insurance trusts. Let me put the chat on, make sure anybody's asking questions. Don't forget to ask questions. This is very common. A lot of people use these, and a lot of people use these wrong. We see a lot of clients come to us with an ILIT that is not funded at all. They have it. They don't know what it is. They don't know why they have it. It does not own their life insurance policies, or they've done it so long ago and they don't have a taxable estate any longer that it really does not serve its purpose. So it's really important that you don't do your estate planning and set it and forget it. You should be reviewing your plan, your documents, your purpose on a continuous basis. We like to meet with our clients on an annual basis to see what's going on, see if anything needs to be changed, and confirm that everything is still working the way it's supposed to work. So if you do have an ILIT, it's really important that your life insurance policy is owned by the ILIT inside the trust. So the trust is the actual owner of the policy. So there's a couple of parts to a policy. There's the owner, there's the insured, and there's the beneficiary. The owner of the policy should be your trust. The beneficiary of the policy should be your trust. I've seen some weird things here where one trust owned it, a different trust was the beneficiary. You don't want to mix and match those things. It should all be consistent. The insured is you typically, right? And to do this properly, your ILIT should have a tax identification number. It should have a bank account. You should be contributing the premiums into this bank account, and then the trust itself, through its bank account, pays the premiums. You do not want to pay the premiums directly, because that's what we call an incident of ownership. If you have any incidents of ownership, the proceeds of this policy will be included in your estate. And that's the whole reason why you do an ILIT, is to keep the proceeds of the policy outside of your estate. If it's in your estate, it's going to be subject to estate tax. If you have a $5 million policy, you're going to pay 40% estate tax on that $5 million if you don't do it properly. So it's really, really important. And then it's really important, that the policy is set up. I'm sorry, not the policy, the trust is set up properly, and that you're looking at it. A lot of people will, you can't be the trustee of this trust. So you're going to name somebody else as the trustee. And a lot of people, they name somebody and then they are no longer on good terms with that person. Maybe that person has died or they're incapacitated. There may not be an alternate. It may not be the person you want to be the alternate. It's really important with irrevocable trust that you set up some flexibility inside the trust. so that you can pivot and make changes, because these trusts are usually going to be around for a long time. So that's very important. Trust protectors can be a fantastic method to use. You can give somebody the power to make changes to an irrevocable trust, which is very helpful. Qualified personal residence trust. This is another really cool thing that you can do if you have an extra property. So it could be an investment property. More so, it's usually going to be some sort of vacation property, second home. You can put it into a trust. It is irrevocable. So let me say, all of these strategies have some component of you're giving something up. Irrevocable. You cannot retain power and control over something and have it be considered out of your estate for estate tax purposes. So in order to do some sort of estate tax reduction, you have to give up some sort of control. A lot of people don't like that, and that's why they end up not doing any planning. There's lots of different strategies you can do, and you have to do what's you're most comfortable with, but they all do require some sort of giving up control. So a qualified personal residence trust, commonly referred to as a QPRT, is where you put this second home into an irrevocable trust and you retain a right. Well, I said you shouldn't do that, right? Well, you're doing it for a certain period of time. So let's say it's a 10-year term. So I'm going to put my property into this trust and I'm going to retain the right to be the beneficiary of that trust for 10 years. If I die during that 10 years, it's included in my estate. But if I live longer than the 10 years, then the beneficial interest of that trust passes on to the next set of beneficiaries, which is usually going to be your children or grandchildren. But doesn't have to be. At that time, if you want to continue to use the property, you have to pay rent as if it's not your property. That's really, really important that you do that. Otherwise, you're going to be considered as still being a beneficiary of that trust, and you still have, some sort of ownership interest in there. So the benefit of doing this type of trust is that, let's say you have $1 million property, you put it into this QPRT. You're going to, the value of that gift is not $1 million. It's going to be reduced by the interest that you retained. So whatever the value of that 10-year period of time is, let's say it's $400,000. And there's tables that you look at that the IRS publishes. So let's say it's $400,000. You only made a gift of $600,000. So the $600,000 will reduce your lifetime exemption. But you're actually giving away an asset that's worth $1 million. On top of that, the bonus is that once the term ends, you're going to pay rent into the trust for the use of that property. So whatever the fair value rent is for that, it sounds like, oh, I don't want to pay to use my own property, but you do if you have a taxable estate, because you want to be able to transfer money from this bucket, your bucket, over to your kids and your grandkids in this other bucket without paying any tax. So if you're wealthy enough to do this, that's a great strategy. So you're reducing your estate by the $1 million, only getting dinged for $600,000, plus you're going to pay rent for the rest of your life or however long the property, the trust owns that property, further reducing your estate. The property can be sold, so that it's at that point the trust owns it. It's not like it's locked in there and nobody can ever do anything with it. They can sell the property, then the property's gone. That's fine. And you can invest the proceeds. You could buy a different property. Everything is still there inside the trust. It's just that you don't have control over it anymore. Whoever you designated as trustee will have control. So let's see. There's some polls being released. Okay. Good answers. Good answers. All right, we're going to move on here. So if you're married, you have some special strategies that you can utilize. You can leave $10 billion to your spouse and you're not going to pay any tax. But when your spouse dies, they're going to pay tax, right? So it's not a total strategy to just pass everything to your spouse and not pay any tax. You have to plan, for both lives. But it is very beneficial if you are married. Upon the first spouse's death, there shouldn't be any tax due. And this can be done inside a trust structure so that if it's a second marriage, or you're afraid your spouse is going to spend everything, or you're afraid your spouse is going to remarry, or any of that, you can put it into a trust structure so that there's some sort of controls over it and it's preserved for the next generation. Upon that second spouse's death, whatever is in their estate plus whatever is in that, we call it a QTIP, a qualified terminable interest property trust, whatever's in that trust that received the marital deduction is going to be subject to tax at that point. So you have to do some proper planning. A lifetime QTIP trust is where you make a gift into a marital trust for your spouse. Now, so this doesn't reduce your estate per se, but it does preserve wealth. It provides control over the wealth, but it's a really great creditor protection strategy. It is really hard to do creditor protection for yourself. Very, very hard. We did a whole webinar on that. It's on our YouTube channel. You can check out creditor protection webinar there. But in Florida, we don't allow what we call first party creditor protection trust. There are some states, about 17 now, I think, that do allow domestic asset protection trust, but Florida isn't one of them. So it's hard to do here. But you can create a trust and contribute assets to that trust for somebody else. And that trust is then creditor protected from that person's creditors. So you can transfer assets into a trust for your spouse, and they're going to be creditor protected. So as long as you remain married to your spouse, it's a really good tool to use to get some creditor protection for your marital unit. A SLAT is a little continuation of that lifetime QTIP trust. It's a trust for the benefit of your spouse. So you're going to get that creditor protection as well. But this is where you make a gift into this trust, this spousal lifetime access trust, and you use your exemption. So for instance, you can make next year a $15 million gift into a SLAT for the benefit of your spouse. And if you're nice to him or her, they might take you out to dinner using that money. And you've used up your full exemption. So you have no more exemption unless they increase it. But once you put the money in there, it's forever outside of both of your estates. So when your spouse dies, it's not taxed at that point. If that $15 million grew to $100 million, it will never be taxed. So it gets all the appreciation out of your estate. It allows the marital unit to continue using the assets and having access to them. It's a really great strategy. There can be some problems if your spouse dies or you do get divorced. There can be issues. So you want to be careful, and these are usually best used in long-term marriages. Florida does allow a back-end SLAT, which means that the grantor spouse could be a beneficiary in the event of a divorce or death of the beneficiary SLAT spouse. I don't think that any of these is a fairly new law. I don't think there have been any cases tested with the IRS, but theoretically, this is an option. It's a little bit aggressive, so you have to weigh your appetite for aggression and audits by the IRS. You have to have enough money to do SLATs. So sometimes people, they want to do 2 SLATs. Well, that's $30 million that you can potentially do. You can't have a $30 million estate and do 2 SLATs. You just don't have enough money. You can't put all your assets in the SLATs. Some assets are appropriate, some are not appropriate, and you don't want to leave yourself with nothing outside of that trust. You still have use and access, to the assets in there, similar to the QPRT, where you can sell assets, you can reinvest them, you can buy other things. You're not completely locked out, but it is an arrangement. It is a trust arrangement. There are remainder beneficiaries. There is a next level. You do have to provide accountings to the remainder beneficiaries or residuary beneficiaries. There are some interesting ways around that by designating somebody who would be the recipient of those accountings, because sometimes people say, well, I don't want to do this because I don't want my kids to know how much money we have. They're never going to work again. So there are strategies that you can employ to utilize these things effectively. So the SLAT can be super, super helpful. You don't have to do two, you could do one SLAT for one spouse and sock away 15 million. That hopefully grows and grows and grows. So both the lifetime QTIP and the SLAT are very helpful strategies if you're married. Grantor retained annuity trust. These are great too. These are, really used in conjunction with other things. In fact, all of these strategies are not like pick one and do it. A lot of times when we're doing estate tax planning, it's like, here's your menu of estate tax reduction strategies, and maybe we're going to pick 1, 3, and 7. And then we're going to review every year, and we're going to assess. And, 1 year, maybe you do an ILIT, and then the next year you're going to do a QTIP trust, a lifetime QTIP trust. It's an ongoing, evolving thing. Your assets are changing. Your estate is changing. Sometimes the law is changing. Your age is changing. Your appetite for giving up control is changing. So it's not a set it and forget it. But a GRAT is definitely something that you're usually going to use in conjunction with something else, because it's a little complicated. But basically, you put some sort of asset into a trust, and it's usually a very short-term trust, 2 years, 4 years, 5 years, and you're basically going to get 100% of the value of that asset back. The purpose of doing it is to exclude any appreciation of that asset during the term. So let's say it's a 5-year term. If the asset was $1 on the day you put it into the GRAT and it ends up being $10 when the term ends, well, you've passed $10 along. I'm sorry, you're going to get your dollar back. You've passed $9 along to your beneficiaries, but you only used up $1 of your exemption. And they have these zeroed out GRATs where if it's, calculated properly, you don't use any of your exemption at all. So you're getting a lot of the asset back. It's really just to pass along the appreciation. It can be very effective. There's something called a rolling GRAT where you just kind of keep transferring that asset into another one and another one and another one, because if it's continuing to grow in value, it can be very effective. GRATs are not good for real estate or things that are going to be difficult to value, because you're going to have to value it over and over and over again. So you don't want to have to get, a valuation of the asset on an ongoing basis. They can be really great for stock, especially, if the market is on an uptick. So certain types of assets are good for GRATs. Not all assets are good for them, but they can be a very effective tool, usually when combined with something else. Dynasty trust and generation skipping transfer tax. So dynasty trust is really, it's not like a separate type of trust. It's just what the trust is for the most part. And this is just a trust that lives on for generation after generation. It's not really set to terminate. And this can be super, super effective with reducing future potential estate tax for generations to come. So the IRS not only likes to tax you, but they want to make sure that every generation gets taxed. So if you try to be cute and skip over a generation and say, oh, my kids don't need any money, I'm going to give it directly to my grandkids. Well, they've already thought of that. And that's the GST tax, the generation skipping transfer tax. So if you do that, the IRS will tax you twice. And the estate tax is already at a 40% rate. So you're paying 40% of the value of the assets. So a lot of people refer to this as a double tax, because when you've generated income, you pay income tax on your income, and then you buy an asset with that after-tax income. And then you pay tax again when you die. So it's not on the appreciation, it's not on the income, it's on the actual value of those assets minus any liability. So the net value of your estate is what you're going to pay estate tax on if you're over the exemption. And if you try to skip a generation, they're going to tax you again. So currently, the GST exemption mirrors the estate tax exemption. And the estate and gift tax exemption are once again unified. There was a period of time where they were ununified, but they're back. So whatever exemption you get, 13.9 million, 99 million, or 15 million, you can use that during your lifetime, or you can use it at death, but you only get one exemption. And you get the same amount for the GST exemption. So if you are going to skip a generation, or you're going to create a trust that's going to pass on to generations, you need to allocate your GST exemption to that trust. So if in 2026 you put $15 million into a trust that's going to pass on to various generations, you're going to allocate your full GST exemption to that trust. And even if that trust ends up being $100 million, it doesn't matter. It's completely GST exempt. But if you go over your exemption, then it's not going to be GST exempt. So not only are you going to potentially pay estate tax, but you're going to pay GST tax when it passes to that next generation. So the tax can be very, very significant for large estates, and it's really important that you do plan properly and plan soon. So generation, dynasty trust, it's not a specific type of trust. It's just a trust that kind of lives on. This could be how a QTIP trust is structured, how a SLAT is structured, how just a regular trust that you're leaving to your kids is structured. Intentionally defective grantor trusts. These are also very powerful. An IDGT, as some refer to it. So it's a good defect. So this is basically a trust that is recognized for estate tax planning purposes. That's not recognized for income tax purposes. So it's as if the grantor, the person who created the trust and put the assets in the trust, still owns the assets, and they still report the income on their tax return, which is a good thing when you have a large estate. Most people say, I don't want to pay tax, but it's a good thing that you're paying income tax, because if over several years you end up paying $1 million of income tax, that further reduced your estate by $1 million. Somebody's going to pay income. Somebody's going to pay tax on that income. So it might as well be you if you have a taxable estate. So these are very effective. This is a very common thing to do with this. Also, again, is not a specific type of trust. This is a characteristic of an irrevocable trust. And sometimes we want it to be an intentionally defective grantor trust, and sometimes we don't want it to be a grantor trust. And there's reasons why you may or may not. There are ways to kind of turn it on and turn it off again. However, there have been some recent IRS rulings that were not so favorable to the taxpayer, so you do have to be careful with that. But this is a really cool tool that you can use. The grantor can put assets in and out of the trust, so you can sell things to these types of trusts and not pay any income tax on them, because it's as if you sold it to yourself. So you can freeze your estate. Freezing your estate is a very powerful tool to use, or strategy, because you're getting all the future appreciation out of your estate without actually using any of your exemption. So if you take an asset that's worth $5 million and you sell it to a grantor trust, you're not going to pay any tax on, if that asset had appreciated since you first purchased it. You're also not using any of your exemption because you made a sale. So theoretically, you're taking back money from the trust, or maybe you're getting a promissory note from the trust. So you're going to get your $5 million back. But if that asset ends up being $50 million by the time you die, you've now gotten a $50 million asset out of your estate with zero use of your exemption. You still have your exemption to use for other things. So again, this is another thing that's just another tool from the menu that you might use in conjunction with something else. Portability. So this is very important for a married couple. At one point, there was no such thing as portability, and everybody had to separate their estates and use or lose their exemption. But now we've got portability. So if the first spouse dies, the surviving spouse gets to use the first spouse's exemption. Very cool. The things that are not cool about it, you must file an estate tax return in order to claim this exemption. I have seen people pay millions of dollars in estate tax because the first deceased spouse did not timely file an estate tax return, which is called a 706, and they lost the portability of the exemption. There is a time frame. It's a long time frame. It's supposed to be 9 months. You get a 6-month extension, but the IRS has been very generous and has given a 5-year stretch term that you can file a 706. So get it done. What it also, portability doesn't do, if the surviving spouse remarries, that's a problem. And it also doesn't apply to the GST exemption. So you can't always completely rely upon portability, but depending on the size of the estate, you might be able to. So transfer appreciation before it happens. We've touched upon this earlier. Getting the appreciation out of your estate is very, very valuable. There's different ways to do it. You can make a sale. You can make direct gifts. So that's, the SLAT, or you can make a gift to a child, a grandchild. You can put them in irrevocable trust so that they don't get the property now. Somebody else can be in charge of it. But if you don't need that asset anymore or that money anymore, make a gift of it, use some of your exemption, and all the future appreciation will forever be out of your estate. Let me see if there's no questions yet. All right. If anybody has any questions, put them in the chat, or if you would like to come live on stage, I think you can just raise your hand, your digital hand, and we'll bring you up. So large gifts when paying tax makes sense. If you have a really large estate and we know you're going to pay estate tax, then it makes sense to make a large gift at some point and pay the estate tax. So I just use a crazy example. You have a $100 million estate. You know you're going to pay estate tax. There's no planning that you can do that's going to reduce your estate to zero under the exemption. So you make a large gift. Maybe you make, a $40 million gift and you pay estate tax, gift tax. The tax that you pay will also come out of your estate. So they call the gift tax is tax exclusive, meaning that you're further reducing your estate by that tax. But if you wait to die to transfer those assets, you're paying tax on the full value. So it's tax inclusive. Post-death planning, final strategies, basis step up. This is really important for more people than those that have taxable estates. So when you die and your assets pass to someone, it gets a step up in basis. So basically, all the appreciation is wiped out. Really powerful. When you do estate tax planning, you're usually losing the basis step up because you no longer own that asset. So it's kind of a, you get one, but you give up something else. So you have to weigh the benefit of, do I want to pay estate tax or do I want to pay income tax? The estate tax is more than the income tax usually. So you have to look at that. It applies to anyone, even if you don't have a taxable estate, it's going to apply. So that's super important. Now, things that get a little bit tricky are if you own assets inside some sort of entity, a partnership, an LLC, a corporation. There is an IRS code section so when you die and you own those things, what you own is the entity itself. You don't own the actual asset inside the entity. There are code sections that allow, if you make an election, to increase the basis. So you get the basis step up of the asset that's owned inside the partnership or the LLC, as long as the LLC is taxed as a partnership. It could actually be taxed as a corporation. There is no corresponding IRS rule for a corporation. So in that case, you're probably going to want to liquidate the corporation in order to benefit from the step up. So that's important that you get that timing right. Roth conversion. So again, if you have a taxable estate, if you know you're going to end up paying estate tax, speak with your financial advisor about converting a traditional IRA into a Roth and paying the tax, because whatever tax you pay is going to further reduce your estate and save that 40% rate. So you can see with this chart, effectively you're saving 62%. When you pass on those retirement accounts, somebody's paying tax on them. Now, they can usually stretch them out for a period of time. The rules are different if you're a spouse or if you're somebody else, or if you're a minor child, or if you're disabled. The amount of time you can stretch it out is different, but at some point, somebody's paying income tax on that. So if you have a taxable estate, run the numbers and see if it makes sense for you to prepay the tax on that, and that way it's no longer taxed, and it will continue to grow tax-free. And then, of course, there are charitable strategies. So you can leave an unlimited amount to charitable organizations and reduce your estate. You can make outright gifts and bequests during your lifetime or upon your death. You can create your own private foundation, which is like your own little private 501c3, where you can put money into this entity and you get to control it. Lots of wealthy families have private foundations. There are lots of rules, but they're not too bad. So private foundations can be great. There's a lot of, there's setup requirements. You have to get approved by the IRS to be taxed as this type of entity. You have to formally form it. And then there's annual filing requirements with the IRS. So there's some work involved. You have to, definitely want to put the time in for something like that. Or there are other things like donor advised funds, which are pretty easy. You can do that with wherever you hold your financial assets. Lots of the brokerage companies have these, and basically it's like a private foundation, but it's a lot simpler. You put some money into this fund, and basically you tell them what charities you want the money to go to, and it's very easy to change over time what charities that they're going to distribute the money to. There are also things like community foundations. Broward County has one. There's lots of others, I'm sure, where you can contribute money and you can tell them what kind of matters and charities are important to you. If you want to support animals or children or domestic violence or anything like that. So you don't have to manage. It takes all the administrative burden off of you and still get you the deduction and still lets your dollars go where you want them to go. And that is the end of our webinar.